Somebody asked a question with respect to the video I made yesterday whether the law is there to encourage the board of directors of a company to break the law. No. The law is there to punish illegality, to punish wrongdoing, and reward good. Now, if you listen to that video, meanwhile, the full video is in our YouTube page. You can do well to follow us there, like and subscribe to our YouTube page. Now, with respect to that video, I said that the acts done by officers of a company are also acts done by the company. That is the position of our law. I also stated that where a third party enters into a business transaction with officers who are not authorized to do such acts, that the company itself will not bear civil liability where liability arises from such a transaction. And that where the company has not made undertakings in connection to that transaction, the company will not also run away from what liability arising from such transaction. But I went further to state that with respect to servants of the company, these are people who are actually in the employment of the company, that the principle of vicarious liability will come into play. Why? Because they are servants, they are working in the employment of the company according to the instructions of their employment. So the company will be solely responsible for acts done by their servants. Now, where it is shown that there is collusion between the servant or the officer of a company and a third party, the company will not bear liability. And then the third party will also not be left to suffer in vain. Because each time a valid contract is created, it creates rights, obligations, duties, and liabilities. So when there is a breach of the covenant or the agreement or the terms of that contract, somebody will suffer loss and another person will bear the responsibility. So when losses occur, somebody will come for redress and another person will have to pay compensation or whatever the cost may be. So because an innocent third party is involved in the relationship between the company and its officer, third party rights have now been created. But even though a third party right has been created, where the company now discovers that yes, this our officer has done something outside his scope, we are ready to ratify it. And that is also why it is very important for the officer of the company to make this position known while entering into a contractual relationship on behalf of the company. You must let that party know that, look, I don't have the final say. What I am going to do with you now will be subject to ratification by the company. So where the company now discovers that, look, there is collusion to defraud, to do illegality, to omit to do something that is legally required, or to do something or the doing of something that is legally prohibited, the company will not take responsibility. So the law is not there to encourage illegality. The law is not saying that the company should break the law and go scot-free. No. In such a case, somebody will have to pay for that damage, which is now going to be a personal liability for such an officer of the of the company. It will become his personal liability that he will carry. He will have to compensate, he will have to pay cost to the innocent party who has suffered injury. I hope this answers your question. Do well to follow us on all our social media pages. We are here to give you premium legal tips to help you make informed decisions, live informed life, and discover the best version of yourself. We'll see you again. Bye.